Good afternoon, ladies and gentlemen, and welcome to this next life sciences session here at Altius. Today's topic will deal with a new regulation that just came out of the EU legislative factory, notably the regulation designed to tackle EU-driven deforestation. A topic that is dear to us, a topic also that we already addressed last year for those of you, and I see there are a number of you that attended our agri-food law seminar back in 2022. At that time, the regulation was still in the proposal phase, so it was still a commission proposal at the time. Today, well, not literally today, but in the meanwhile, the regulation has been published, and it actually entered into force the day, it was yesterday, on the 29th of June. So it's a very hot topic. Now, luckily, the final text as it has been published has been polished and has taken out most of the sloppiness and the unclarities that were present in the European Commission proposal. So that's a good thing. It's not flawless, as we will see, but in the end, I think something decent has come out of it. Now, it's of course always the risk with heartwarming and much needed green initiatives like this one, that it risks to turn into a disproportionate administrative burden on, in this case, operators and traders. We all have freshly the Nagoya Protocol and the EU compliance regulation dealing with the Nagoya Protocol in mind. And in fact, this regulation has many resemblances to that legislation. So we will see during this presentation whether the EU legislator has done a better job in terms of imposing this administrative burden on operators and traders. Perhaps before we start, one personal critical thought. It is peculiar to see that the EU legislator has apparently been able in a relatively short time frame to impose these rules on products and commodities that come from outside of the European Union, despite the fact that the regulation is not limited to products from outside the European Union, whereas initiatives that are pending to tackle the issue of the future of forests within the European Union, such as the nature restoration law, seems to be more difficult to get through the legislative process mill. But that's a purely personal thought to put things into perspective. So, well, you can read the disclaimer in your own free time. I forgot to include the table of contents, but just to specify, my name is Philippe de Jong, and my slides, yeah, this is it. I'm a partner here at Altius in the IP and Life Sciences team, and I will do this presentation today with my colleague Bart Bollen. And we subdivided the presentation. I will first give you an overview of the rationale behind the regulation, as well as a short discussion on its scope and an introduction into the general prohibition on operators to place non-compliant products on the market. And after that, Bart will look into the due diligence obligations more concretely, as well as into the member state obligation and the so-called snitch line provisions of the regulation. So to kick off with the rationale behind the regulation, initially the proposal from the Commission was entitled, and it actually still carries that title today, at least partly. The Commission proposed a regulation on the making available on the Union market, on the one hand, as well as export from the Union of certain commodities and products associated with that deforestation. As I've already said, the quality of that document, as we discussed 2 years ago during the agri-food seminar, was debatable. But the underlying idea has remained the same ever since, notably that the regulation was supposed to put an end, or at least to decrease the EU consumption of products from supply chains that are associated with deforestation and also forest degradation, on the one hand. On the other hand, to increase, obviously it's the reverse side of the same medal, EU demand for deforestation-free commodities and products. And finally, to impose Nagoya Protocol-like mandatory due diligence rules in so-called FERC supply chains. And I do wish to emphasize that the term FERC that we will continue to use throughout this presentation, simply because we use it in the past and because it's easy to pronounce, it's actually no longer fit for purpose, because FERC refers to forest and ecosystem risk commodities, whereas the only thing that the regulation is occupied with are actually forests. So no other ecosystems are in place anymore. That was initially the idea. But so you know, we continue to call them FERC. Okay, so perhaps to put things into perspective a little more, there was, and there currently are still, as you probably know, a number of legal initiatives ongoing, including the Corporate Sustainability Due Diligence Directive, of which, or in relation to which, the European Parliament has recently, very recently, adopted its position. It is to be understood that this regulation on deforestation is complementary to those other due diligence obligations in other areas of EU law. The Council had initially suggested in one of its comments that it should be harmonized with, which led to a notion or idea at the time that perhaps the two pieces of legislation would be merged. Now, that is very unlikely to happen. Simply, first of all, because the regulation in the meanwhile exists, also because the other corporate sustainability initiative is a directive and not a regulation, and thirdly, because also the personal scope is different, as the corporate sustainability due diligence directive will apply only to companies with an annual turnover of, I believe, over 150 million euros. So it is complementary to, and actually in the recently issued frequently asked question documents from the European Commission, it is emphasized that to the extent that companies would have due diligence obligation under these other pieces of legislation, in particularly the CSDD directive, that they would be able to fulfill these obligations under that legislation without having to repeat the same due diligence obligations again under this separate regulation. So the two will have to be read together, and they are complementary, but they are not one. Perhaps one final comment in relation to the timber regulation. As you may know, there has been, since quite a number of years, a regulation out there with very similar obligations and rules as the one that are presented in the current regulation, notably the timber regulation, which prohibited certain operators to place timber and wood coming from certain areas of the world on the market within the EU. So the present regulation organizes what I would call a managed repeal of the EU timber regulation. The timber regulation will be replaced as of the 30th of December 2024 by the present regulation, with a number of exceptions, such as, and I read, that it will continue to apply until the 31st of December of 2027 for all products that have been produced prior to the entry into force of the regulation, so that is yesterday, and placed on the market before the 30th of December 2024. For everything else, also products placed on the market after the 30th of December 2024, the present regulation, so the EU deforestation regulation, will apply. Okay, so let's look into scope now. There are four scopes, so to speak, that we need to look at. There is the personal scope, the territorial scope, the material scope, and the temporal scope. So let's start off with the personal scope. So who is the regulation directed to? Well, it is directed to a very broad category of people or persons. To start with, and predominantly operators. Operators is a class of people that is broadly defined as any natural or legal person who, in the course of a commercial activity, places relevant commodities and products, and we will get back to what these terms actually mean, on the market, or exports them, as I've already said, from the EU. The term placing on the market is defined as the first making available on the EU market. So basically, an operator is everyone who places a commodity or product on the market in the EU for the first time. The term making available for the rest is also defined, and it is defined where you can see in the under the second bullet where we discuss traders as any supply of a relevant product for distribution, consumption, or use. So that is a broad category of activities on the EU market, again, in the course of a commercial activity, and whether in return for payment or free of charge. Now, to the extent that the commodity or the product is placed on the market, so first made available by a non-EU operator, for the purposes of this regulation, the first natural or legal person that is established in the EU who makes the relevant product available on the market will be considered as an operator, simply because otherwise the rules would not be enforceable against the non-EU operator. Luckily, the Commission, or the legislator, has departed from the wording that it chose initially in this context, where it had said that it is the person who buys or takes possession of these products as a first entity in the European Union that will be considered an operator. So these words have disappeared. I don't think, in fact, the scope has changed, but at least it is now clarified, pretty simple wording, that it is the person established in the EU who makes the relevant products available, which is based on a definition. So far for the operator, the regulation also addresses traders, and traders are also persons that make available these commodities or products on the market, with the difference that they don't do it for the first time. If it is done for the first time, they are an operator. If you further redistribute the products, you are a trader. And the definition of the trader indeed says that it is any person in the supply chain other than the operator who, again, in the course of a commercial activity, makes relevant products available on the market, with the latter, as I've already said, defined as well in the regulation. Now, one thing I would like to, or two things that I would like to highlight in addition, as Bart will explain further on in the presentation, the personal scope is also affected by the SME status of the operator or the trader. If they are SMEs, and that is particularly relevant for traders, rather than for operators who do not particularly have a large benefit from that qualification. But if somebody qualifies as an SME, they will have lighter due diligence obligations than if they are not. Another point that I would like to highlight in this case is that an operator, or the notion of operator, is assessed per product in what we will look at in the next slides, Annex 1. So that means that there may be multiple operators acting in the same production chain, whereby the downstream operator transforms the product that is imported or first placed on the market by the upstream operator. In such a scenario, the downstream operator will not be a trader, but it will be considered as an operator and hence also has the same obligations as the upstream operator. And what I meant by Annex 1, and perhaps it would have been ideal if we could already have a look at the next slide, but we'll get there, but just already as a sneak preview, if I take the example of a company X, for example, that is an operator who first makes available and hence places on the market cocoa butter into the EU, then we look at whether cocoa butter is included in Annex 1. We conclude that the answer is yes. So hence the operator must fulfill the due diligence obligations and other obligations under the regulation. However, once the operator X then sells the cocoa butter to another person, let's call him person Y, that person Y turns the cocoa butter or makes chocolate with the cocoa butter, then he transforms the first product into a next product. So it is not simply a vertical activity whereby the initial product is further marketed. No, it is used to make another product. And in that case, we again need to look at whether the resulting product is a part of Annex 1 to conclude that then also person Y is equally an operator which will have to fulfill the requirements under the regulation. Again, as Bart will explain, with the possibility to refer to the due diligence already carried out by the first operator. However, if then the product, so in our case, the chocolate, ends up in the hands of another third party who, for example, makes biscuits with the chocolate, then in that case, we need to conclude that biscuits are not a part of Annex 1, and hence the third party or person Z, so to speak, will not have any obligations. So you see, it's a cascade of logic that you need to follow in order to know whether you're covered by the regulation, but generally speaking, the regulation targets operators and traders. If we then look at the material scope, and again, I wish to repeat that the use of the term FERC is actually, legally speaking, not correct anymore, because I can see a number of additional people have joined. In the meanwhile, as I explained in the beginning, we continue to use the word FERC as it featured in the initial European Commission proposal, simply because it's easy to pronounce. But the E in the FERC is actually no longer relevant because it referred to other ecosystems than forests, which is no longer covered by the present regulation, at least in the way that we read it. Now, the initial Commission proposal in terms of material scope of the regulation referred only to cattle, cocoa, coffee, oil palm, soy, and wood. The European Parliament, during the course of the legislative process, had then suggested to include quite a large group of other commodities, including crustaceans, poultry, maize, cane sugar, ethanol, and rubber. But finally, in the regulation as it was published, only rubber has been retained from that group as being part of the commodities that are being covered by the regulation. Now, in addition to these commodities, or the FERC, there are also products which are derived from these products, so FERC derivatives, so to speak. Now, these products can either be intermediary products or final products, but in order for them to be covered, first of all, just like the commodities, they must be included in Annex 1 of the regulation. And secondly, the products must also, according to the regulation, either contain, have been fed with, or have been made using FERC. Now, I do wish to comment in relation to the have been fed with, that seems to play no practical role within the regulation. At some point in time during the legislative process, the Council had suggested to delete that. Apparently, the legislator, which includes the Council, of course, didn't listen to the Council, and it has remained in the text of the regulation, but there are no examples, as far as I can see, where products that enter the EU market and that result from a animal, for example, having been fed with a certain commodity or other product would be covered. For example, you won't see any reference to meat coming from a cow who ate soy, or, for example, maize that comes from a plot of land that has been subject to deforestation. It doesn't go that far. Anyway, so these products and these commodities, they must, as I said, be included in Annex 1. We took two examples at the bottom of the screen from Annex 1. Annex 1 is a lot larger than that. And we refer to cocoa and soy. In the interest of time, I will limit myself to cocoa. So you will see the relevant commodity is indeed cocoa. And the relevant products that are covered by reference to the combined nomenclature, which is used in the context of customs proceedings, are, for example, cocoa beans, cocoa shells, cocoa paste, the cocoa butter that I mentioned before, cocoa powder, and in the end, also chocolate. Any other product that is not listed in Annex 1 is not subject to the requirements of the regulation. So Annex 1 determines the material scope of the regulation. Then that brings me to the territorial scope. Now, the territorial scope is multifocal. First of all, there's a downstream aspect, and there's secondly an upstream aspect. The downstream aspect is the one we've actually already covered. So what is covered is the importation or the making available, placing on the market of FERC and FERC-derived products, so commodities and products, on the EU market and also the exporting from the EU market. So that is clear. That is the downstream activity. The upstream activity, however, it refers to the country of production. And as Bart will explain, the country of production is relevant because the due diligence provisions of the regulation require that products have been produced in accordance with the relevant legislation in the country of production, because otherwise the product will be considered to be non-compliant. So very much akin to the situation under the Nagoya Protocol, the country of production is essentially the country of origin, but I will say something about the country of origin in a minute. The country of production is defined in the regulation as the country or the territory where the relevant commodity or relevant commodity used in the production of or contained in a relevant product was produced. Quite frankly, I do not see the difference in this definition between relevant commodity on the one hand, and then after the relevant commodity used in the production of or contained in a relevant product. Even if it is used in the production and so forth, it is still the relevant commodity. So this addition is somewhat unclear. In any event, the term produced is defined as something that is grown, harvested, obtained from, or raised on relevant plots of lands, or as regards cattle on establishments, with bearing in mind that there are specific definitions for plots of land and establishments included in the regulation. So essentially, if we go back to cocoa, the cocoa commodity will be from the country of production, Peru, for example, if it has been grown and harvested in Peru. Now, peculiarly, the regulation also contains a definition of country of origin. However, and it refers for that to Article 60 of the Union Customs Code. However, there is no practical use of the term country of origin within the regulation, which is rather peculiar. There's actually only one reference, which is in Article 10.2 of the regulation, in which it is said that the risk assessment to be carried out by operators shall take into account concerns in relation to the country of production and origin, such as the level of corruption. It is unclear whether this adds an additional criterion which is completely dissociated from the issue of deforestation, because you could say that, well, for example, looking at the definition of country of origin and bearing in mind that if multiple countries are involved, goods are considered to be from the country of origin if they have undergone in that country their last substantial economically justified treatment. So you could say that if you import a cocoa product from Peru in the UK, then Peru would be the country of production and the UK could arguably be the country of origin. Would you then, aside from the issue of deforestation, have to look at whether the UK is subject to corruption? That would seem very strange, but it would be a literal interpretation of that peculiar Article 10.2. Presumably, it is simply a matter of oversight. Finally, in terms of scope, the temporal scope. Temporal scope. Now, temporal scope, also here, it's a peculiar circumscription. In a nutshell, however, as I've already explained, the regulation entered into force yesterday, so on the 29th of June 2023. However, as you can see from the final bullet on this slide, it will only start applying 18 months after the entry into force for normal undertakings, 24 after the entry into force for micro undertakings and SMEs. So concretely, that is the 30th of December 2024 for the first category and the 30th of June 2025 for the latter category. And the law, the regulation makes it clear that it does not apply to relevant products before that date, produced before that date. So basically, the entry into force triggers a preparation period for operators and traders to become accustomed with the provisions and the obligations under the regulation so that they're ready by the two dates that I mentioned to apply it in practice. However, there's a second temporal criterion in the regulation, And I call it the material temporal scope. Material in the sense that the temporal criteria that I just mentioned, so the applicability of the regulation, refers to the obligations of the persons covered by it, whereas this other cutoff date refers to the materials. Any material products that have been obtained from commodities coming from a plot of land before, that is presumably subject to deforestation, before the 31st of December 2020 are completely out of scope. Remember, in the context of the Nagoya Protocol, there was also a cutoff date back in 2014. Anything that was obtained before that is not covered. So a similar cutoff date has been provided here on the basis of a purely political choice. And in order to assess, as we will see in the next slide, whether something is deforestation free, you will therefore only have to take into account potential deforestation activities after this date. Anything that has been obtained before that date, even if it involved deforestation, will not be covered, at least not by the EU regulation. So in a nutshell, in summary, there are no obligations under this EU regulation before the 1st of January 2025. So that's the personal temporal scope. But even after that date, you will only have to take into account products that have been obtained from land that is potentially subject to deforestation after the 31st of December 2020. Okay, before I pass the floor on to Bart, who will deal with the concrete due diligence obligations, I will first briefly discuss a general obligation, or better, perhaps a prohibition, that is included in Article 3 of the regulation on operators and traders, notably the prohibition to place on the market or make available on the market or export from the EU market commodities and products that are not deforestation free, that have not been produced in accordance with the relevant legislation in the country of production, and or that are not covered by a due diligence statement. I read it negatively now. I realize the slide is in positive terms, but obviously it's the reverse side of the same medal once again. So let's look into these 2 or 3 obligations. First of all, in relation to deforestation free, a product or a commodity is considered to be deforestation free if the relevant product either contains, has been fed with, or has been made using relevant commodities that were produced on land that has not been subject to deforestation after the 31st of December 2020. And deforestation in that context is defined as the conversion of forest to agricultural use, whether human-induced or not. Interestingly, and this was also part of the debate that the legislators have had, it is limited to agricultural use. So other uses are not envisaged or covered. So for example, urban use or the building of a highway is not of concern for this regulation. Obviously also because on a highway you cannot grow cocoa, but it is limited to agricultural use. And forest has a specific definition, notably land spanning more than half a hectare, with trees higher than 5 meters and a canopy, so that's the top of the tree, covering a cover of more than 10%. Or if they haven't reached that yet, trees that have the potential to reach that height. So that means trees able to reach those thresholds in situ. Commission has clarified that that is what that means. There is a specific criterion for wood, and you may think that this is an alternative criterion, but the Commission in the frequently asked questions that have been published has clarified that this comes in addition to the criterion that it must be deforestation free. It must also not have led to forest degradation. And then again, there is a specific definition for forest degradation that you see on the screen, which I will not read out loud because it would probably take us too far in terms of timing. So that's the first condition. The product must be deforestation free. In addition to that, it must have been obtained, produced in accordance with the relevant legislation of the country of production. Again, remember the Nagoya Protocol where also local ABS legislation needed to be complied with. Now, the peculiarity about this condition is that it, again, seems to be a criteria that is completely dissociated from the aspect of deforestation, because we saw under the first condition, the product must be deforestation free. Here, the requirement is simply that the product must have been produced in accordance with the relevant legislation in the country of production. And from the list below, you, for example, see labor rights. So this seems to suggest that in addition to bearing in mind whether it doesn't come from land that has been subject to deforestation, you must generally take into account the question as to whether labor rights were respected during the production of the product, regardless of whether this alleged violation of the labor rights has a clear link with deforestation. So if these first two general obligations, because the third one, notably the obligation to perform due diligence, that's a separate criterion. Only if these two first obligations are not met, then the product will be considered to be non-compliant. The due diligence statement as such does not give rise to the conclusion that the product is not compliant. The non-compliance is assessed only in relation to the origin of the product, so deforestation free and produced in accordance with the relevant legislation of the country of production. The third criterion on the due diligence statement is linked to the compliance in the country of use. Again, very similar, an echo from the legislation on the Nagoya Protocol. And I think with that, I've covered the scope of the regulation and the general obligation or prohibition on operators and traders. And then I will now give the floor to Bart, who will dive into the rest of the presentation. I also hand you this thing.
Thank you, Philippe. Good afternoon again, everyone. Also from me. My name is Bart. I'm an associate here at Altius, and today I will be guiding you through what you could call the substantive provisions of the deforestation regulation, meaning the actual due diligence obligations that you can find in the regulation, but also the provisions that regulate how these due diligence obligations are to be enforced. That being said, I propose we immediately dive into the due diligence obligations, and we start with the obligations incumbent upon operators, because as Philippe has explained, there are two types of legal persons covered by the regulation: operators and traders. So first of all, maybe a rather obvious point probably, but nevertheless, is that the due diligence needs to happen before the relevant FERC products are placed on the EU market or exported from the EU market. This of course ties in with the underlying goal of the EU deforestation regulation, which is to make sure that these products that are not non-compliant, and if they were to be found non-compliant with the regulation, are kept off the market or don't leave the EU market. On the other hand, if the due diligence carried out by the operator leads to the conclusion that the relevant products are compliant with the regulation, that is in principle not the end of the road. Operators will need to submit what is called in the regulation a due diligence statement to the competent national authority through a register information system, which is an online system that still needs to be set up by the European Commission at EU level, where the national authority can then verify if everything is in order with the regulation. Operators can, however, not freewheel as to the content of this due diligence statement. It needs to include at least the following elements. One, a clear confirmation that the due diligence was actually carried out by the operator. Two, confirmation that no or only a negligible risk was found related to the possible violation of the deforestation regulation. A negligible risk is defined in the regulation as no cause for concern after a full assessment of both the product-specific and general information on compliance, which is still a high threshold to reach if you think about it. Lastly, the due diligence statement must also contain the information that is included in Annex 2 of the regulation, which is basically some sort of template that the EU legislature has prepared of a due diligence statement, and which I will show to you on the next few slides. But before that, after the due diligence has been submitted to the competent national authority through the online information system, the operator is still obliged to keep that information that it had submitted for 5 more years and hand it over to the authorities if it is requested to do so. An important point in this regard is that the operator remains at all times responsible for the compliance with the EU deforestation regulation. This also implies, in our understanding of the regulation, that if an operator were to retain the services of a firm for assisting it in carrying out these due diligence obligations, the operator can then point fingers to the other firm if things go wrong when the national authorities do find a violation of the regulation. This is, I think, important to keep in mind, because these obligations stick to you like glue, to use a figure of speech. You cannot just get rid of them. You need to comply with them and bear the responsibility for them. As I announced, this is a screenshot from Annex 2 of the regulation, which is the minimum information that the due diligence statement needs to contain. I'm not going through the whole annex bit by bit, because that would probably take us too long. But as you can see, it contains some rather basic information, such as the identification of the operator, the relevant product, its measurements, so how many liters or how many kilograms. This is the second part of Annex 2, and other important elements are the country of production, which is something Philippe has already explained, the geolocation of all plots of land where the relevant commodities were produced, because of course that is what you need to determine whether that commodity is deforestation free or not. You need to know where it actually comes from. What also needs to be included is this standard confirmation that I told you about a few slides ago, that due diligence was carried out at a certain point in time and that no or only negligible risk was found as to the possible non-compliance with the regulation. We now get into the part of the presentation about the content of those due diligence obligations. What do operators actually need to do in order to be compliant with the regulation? And well, there are quite a few things that operators need to do in this regard. The first thing they need to do is set up a so-called due diligence system, which means a framework of procedures and measures covering that operator's relevant business operations. Now, that system should allow, according to the regulation, the operator to collect, organize, and keep for a minimum period of 5 years the information demonstrating compliance with the deforestation regulation, such as the description of the product, how much of that product was produced, where does it actually come from, not only the country of production, but also the geolocation of all plots of land where the relevant commodities that the product contains were produced, the details of the operator's suppliers and customers, etc. Collecting the information is, of course, only the first step in the whole chain, because secondly, the operator will also need to verify and analyze the information that it obtained, meaning, is it actually correct, what I have obtained, and what does this tell me about the possible non-compliance with the regulation? After an operator has gone through all of this, he will need to ascertain and demonstrate that the risk of non-compliance is negligible or does not exist. The operator does this based on a risk assessment that he will need to share with the competent national authority. And how an operator must carry out the risk assessment is not actually regulated by the deforestation regulation, but it does contain the minimum criteria that need to be taken into account by the operator. These include, for example, the complexity of the supply chain, so how many actors are active in that supply chain, how often does the product move around for further processing, the so-called substantiated concerns submitted to the competent national authorities, which is something I'm not going to say anything about right now because I have a dedicated slide to that for that. Also relevant are the source, reliability, validity, and links to the other available documents of the collected information, and also the country benchmarking system, which is one of the hallmarks of this regulation, and which is something we will also talk about later on in this presentation. But I can already say that it's basically a deforestation risk ranking of countries around the globe. If after the risk assessment, it turns out that there is indeed a risk of non-compliance with the deforestation regulation, which is non-negligible, the operator must adopt so-called risk mitigation procedures and measures that are adequate to reach the lower safe level of no or only a negligible risk of non-compliance. Now, the regulation does not oblige operators to stick to a certain a priori defined measure or procedure, but it clarifies that it could include things like requesting additional information from other actors in the supply chain about the product in the country of production, undertaking independent surveys, organizing audits, etc. Furthermore, operators will also need to be able to demonstrate how they actually carried out their risk assessment and risk mitigation. Let's say that as an operator, you carried out your risk assessment, you came to the conclusion that there is indeed a risk of non-compliance, which is not negligible. Thus, you take risk mitigation measures and you lower the level of risk to only negligible. Now, if a competent national authority in one of the member states then decides to check your goods or the products that you imported into the European Union, you will need to be able to show how you came to that conclusion and that the product is of only a negligible risk of non-compliance and was thus entitled to be put on the EU market. Another obligation to be respected by operators is that they need to put in place a risk management policy, as it is called in the regulation, which includes model risk management practices, reporting, record keeping, internal control, and compliance management. And for non-SME operators, the appointment of a separate compliance officer within their business operations. And for non-SME operators, there's also independent audit function foreseen to check the same requirements. Another important obligation for non-SME operators is to report publicly, as widely as possible, as the regulation called it, about the due diligence they have undertaken under the regulation. More concretely, this needs to happen every year, so annually, but it can also be online. So if the operator is of such a size that it produces a very broad annual report, then how we read the regulation, a dedicated section of that report concerning the due diligence undertaken for this regulation would be fine. If an operator is also caught by another due diligence act of the EU, which was already alluded to by Philippe, then they have the possibility to integrate the information required by this regulation into the reporting for the other EU legal act concerning due diligence in supply chains. So essentially, this means that there can be one value chain report, so to speak, that covers both EU due diligence acts, but there can also be two separate acts if the company deems that, or the operator deems that useful. The last due diligence obligation for operators is what we call the post-marketing notification obligation, meaning essentially that when an operator is made aware of relevant information, including, again, substantiated concerns that a product has already been marketed in the EU is not compliant with the deforestation regulation, the operator has the obligation to immediately inform the competent national authority thereof. This could mean that if an NGO, for example, informs an operator that there are indications that their products are at risk of non-compliance with the deforestation regulation, the operator is, by virtue of the regulation, obliged to refer this to the competent national authority. It is not up to the operator itself to assess whether that information is actually true or not. That is up to the national competent authorities. There is, in other words, no discretion on the side of the operator. He just needs to notify immediately the competent national authority. As Philippe already noted in his part of the presentation, apart from operators, there are also traders active in the supply chains. However, they are not always treated the same as operators and therefore have different due diligence obligations depending on their size. So traders that are SMEs, small and medium-sized enterprises, are subject to what you could call a due diligence light obligation in relation to products they intend to make available on the market. This means in practice that they are exempted from the majority of due diligence obligations that apply to operators, which includes the submission of a due diligence statement. However, there are still two obligations that SME traders need to respect. First of all, they need to collect and keep for a minimum period of 5 years the details about their suppliers, which could be operators or traders, and their trader customers. Secondly, they also have this post-marketing notification obligation that I just talked about towards the competent national authorities when they are made aware of new information about the possible non-compliance of their products with the deforestation regulation. As to the other subcategory, the non-SME traders, they are effectively treated the same as operators under the EU regulation and must also in principle adhere to the full package of due diligence obligations that have been found in the regulation. The regulation also clarifies that if the operator in the value chain is not established in the union, then this does not mean that the obligations do not need to be followed somehow. It has namely been decided by the EU legislature that the first natural or legal person established in the EU who buys or takes possession of the products is considered to be an operator for the purposes of the regulation and who will thus need to follow all the due diligence obligations incumbent upon him. The deforestation regulation as a directly applicable piece of EU law, first of all, lays down obligations for operators and traders, which is what we just talked about. But this regulation also needs to be enforced because otherwise an EU legal act doesn't have much meaning. The EU institutions have taken the political decision to opt for a decentralized system of enforcement, meaning that it will be primarily to the member states and more specifically the competent national authorities to make sure that the regulation is adhered to by operators and traders. Now, speaking of competent national authorities, these need to be appointed by the member states and must be communicated to the European Commission so that the Commission can publish a list on its website of which national authority is designated by which member state. Now, it could perfectly be, in our opinion, that an existing service within the national administration is tasked now with the enforcement of the regulation. There is in principle no obligation upon the member states to establish a whole new department or service that is solely dedicated to the enforcement of the EU deforestation regulations. What member states do need to ensure is that the authority that they designate has adequate powers, is independent, and has sufficient resources to enforce the deforestation regulation. Now, what will be one of the main activities of the competent national authorities is that they will carry out, in principle, unannounced checks on operators and traders to see whether the deforestation regulation is actually complied with. They will do this, in principle, on a risk-based approach, because it will be impossible in any way to check each and every container of relevant goods that comes into the EU or leaves the EU market. But the competent national authority will develop plans to that end, and it will take into account certain criteria, such as the country benchmarking system, which we will still get to, the history of compliance of the operator or trader in question, etc. In any case, the competent national authority is obliged to adopt an enhanced scrutiny for high-risk countries, meaning that products originating from such countries will be checked more regularly, as well as the operators and traders involved. Now, all of this can happen at the borders of the EU, not only when it enters the EU territory for the first time, but also when it is being readied for export outside of the European Union. By virtue of the deforestation regulation, competent national authorities will be able to take immediate interim measures, such as seizure or a suspension of a license when faced with non-compliant products. They can also force operators or traders to take so-called corrective action to end the non-compliance with the regulation. This could be rectification of a due diligence statement, withdrawal or destruction of the relevant products. The competent national authorities, they may also impose so-called DEP penalties. D stands for dissuasive, so that the penalty must be of such an intensity to dissuade the operator or trader from non-compliance because the costs of non-compliance would be too high. The E stands for effective. It needs to put an effective end to the violation of the regulation. And P stands for proportionate, which means that the penalty cannot go further than necessary to obtain the goal, which is the compliance with the deforestation regulation. Lastly, competent national authorities will need to exchange information with their colleagues in other member states and also the European Commission. And I think the last element is quite important because there is some sort of name and shame mechanism built into the regulation, which gives the possibility to the Commission to publish on its website a list of final judgments handed down in the national courts against infringers of the regulation and the actual penalties imposed on them. And there must also be an annual report to the Commission on the competent national authorities' enforcement activities in relation to the regulation. We now come to what Philippe has called the snitch line, and which is a term that we will continue to use throughout this presentation. Now, the snitch line is, of course, not a term that you will find in the regulation necessarily, but it's the same idea because it allows for a natural or legal person to submit substantiated concerns to a competent national authority, which may then act upon them when they deem, based on objective circumstances, that one or more operators or traders are not compliant with the regulation. Now, to ensure access to justice and the right to an effective legal remedy, the regulation does foresee directly that the national decisions must be subject to judicial review by the courts. This concerns not only the procedural and substantive illegality, for example, was the right to be heard respected, that is procedurally, or did the national authority interpret the law correctly, that's substantively, but also the failure to act, meaning that if after a substantiated concern has been given to the competent national authority, the authority decides not to pursue action, and that can then be the subject of an action for failure to act by, for example, an NGO. Finally, get to the lot talked about country benchmarking system. And it's one of the underlying mechanisms of the deforestation regulation. What it actually is a what you could call a three-tier system for the assessment of countries or parts thereof. It doesn't have to be the whole country. The three tiers relate to the risk of deforestation and are designated as low risk, standard risk, or high risk. Now, as I already alluded to, bear in mind that a part of a country can present a different tier of risk in relation to another part of the country or the rest of the country in question. The country benchmarking system is actually still in its infancy, meaning that effectively nothing has been decided yet as to which country gets which risk tier. The default position for the moment is that all countries present a standard risk, unless the European Commission decides to alter the tier, either going from standard risk to low risk or from standard risk to high risk, which it can do on the basis of a list of criteria in the regulation. although it's not really, which you can see on the screen, and with the caveat that it is not really clear if this is really a limitative list that the Commission needs to respect, or that it can also take into account other criteria at its discretion. Now, in any case, this list will be published by the European Commission in the official journal of the EU through an implementing act, meaning, of course, that it will go through the famous comitology procedure, aka the committees of representatives of the EU member states who also get a say in this. And we would probably expect that it will lead to a considerable amount of lobbying by foreign nations with the member state, especially those who already feel the storm coming and want to avoid being designated as a high-risk country, because it will then be seen as less attractive for operators and traders to get their products from. If there is a change in status, this will be notified to the country in question. Now, I think it remains to be seen whether foreign states would try their luck before the Court of Justice of the European Union in the event that their risk tire is negatively altered, because it will be a formal decision by the European Commission. So I think that is something to look forward to, also from an international law perspective, whether foreign nations will go through the trouble of fighting this tire system if it affects them negatively. Now, finally, the European Commission has to develop partnerships and cooperation mechanisms with producer countries, and especially, of course, those who are at a high risk. The preamble of the regulation actually seems to introduce a sort of active obligation for the Commission to cooperate with high-risk countries to reduce the level of risk to standard risk, or, if possible, low risk. But this seems to be more an obligation of means rather than an obligation of results. Now, some final words from me regarding the final steps to be taken in regard to this regulation. As you probably know, and as Philippe already mentioned, the regulation has been published on the 9th of June 2023, and it entered into force actually yesterday, which was 20 days following the publication. However, that does not mean that companies are immediately thrown into a pool full of the diligence requirements without something to hang on to. They do have something to hang on to, and that is the adjustment period, which was also mentioned by Philippe. There is a default period of 18 months after the entry into force, meaning that the main due diligence obligations shall apply from the 30th of December 2024 onwards. Micro undertakings and small undertakings, they benefit from a slightly longer adjustment period, namely one that ends on the 30th of June 2025. A final comment from my side is that the Commission will still need to adopt multiple delegated and implementing acts to really flesh out the substance of the regulation. I already mentioned the list of countries and their risk tires, which will happen through a Commission implementing act, which goes through comitology. But there are also other instances where the Commission needs to actively intervene. For example, if a change occurs as to the combined nomenclature numbers in Annex 1 in the Customs Code, then of course the regulation also needs to be adopted. But that does not need to go through the whole legislature. It will be a delegated power to the European Commission to change Annex 1 accordingly. That was everything I had to say from my side. I already want to thank you for being here, for listening to us. Hopefully you found it interesting and you learned something new, what you didn't already know about the EU deforestation regulation. Now that the presentation has ended, we remain at your disposal for questions if there are. If you would like to send us an email with your questions, that's also fine. But for now, we remain at your disposal, and we thank you for your attention. See you.
If there are no further questions, then I think that's a wrap. And we thank you for your attention, and we hope to see you at our next life sciences session, which will be announced shortly. Thank you and goodbye.